but now over the last 70 years, really, that kind of discussion no longer takes place before the court. And Article 14, state shall not deny to any person equality before the law, which incorporates the fundamental principle of the rule of law that everybody is equal before the law, so nobody shall be denied. And then or the equal protection of the laws within the territory of India. So everybody is also entitled to equal protection of the laws. And these are two ways of looking at it, that you shall not be denied the protection of the law, and you will also obtain positively the positive protection of the laws. Now, when I finished my class yesterday, I realized I should have also referred to you one thing, which is when we were looking at the word person. The word person, of course, is not defined in the Constitution, but then I remember that in the Indian Penal Code, there is a definition of person, and so I pulled it out. And now, what's the definition of person in Section 11 of the IPC says, and I thought I should draw your attention to this. Person includes any company or association or body of persons, whether incorporated or not. So here is the gateway for artificial persons also being treated as persons under the IPC. For fixing of criminality. So natural persons, but also artificial persons. So artificial. But then when you look at it in terms of the IPC, there's another section, section 47. And section 47 defines what is an animal. Okay. And it says 47, the word animal denotes any creature, living creature other than a human being. Okay. So one way to interpret the person would be to exclude animals. That is, if you're wanting to incorporate the provisions of the Indian Penal Code while interpreting. But as you know, you must have realized this now, having spent 2 years in law faculty, that the doors are always open to reinterpretation and opening it up. And therefore, since 11 is inclusive but 14 is rather clearer and narrower, you are free to take up the kind of interpretation that at least I have taken. Okay. But of course, not mandatory, you're free to have your view. So now 14 tells us that state shall not deny to any person equality before the law. That is, everybody must equally have the benefit of the law. That is, you should not have a person who's outside of it. Now, very famously, a 7-judge bench of the Supreme Court in Budhan Chaudhary versus State of Bihar, AIR 1955, Supreme Court, page 191. And I want to quote, actually, I pulled this out because I wanted to quote these two lines here, because sometimes you will find this one-line thing in all the textbooks. It's actually from this particular judgment, and it says, while Article 14 forbids class legislation, it does not forbid reasonable classification for the purposes of legislation. Let me repeat. Article 14 forbids class legislation but does not forbid reasonable classification for the purposes of legislation. Now, what do I mean by class legislation? Meaning, as a class, you should not discriminate and prejudice somebody fully. However, if you can show some reasonable grounds why you are treating an entire category differently, then it will become valid under the doctrine of reasonable classification. So, for example, if you look at Article 300 in our Constitution itself, Article 300 deals with the Union of India and the governor differently. And it also tells us that there is no personal liability for the president and the governor of India. Right. and therefore you cannot sue the president or the governor in their personal capacity. But okay, I'll be louder and slower, maybe that will help. If so class legislation distinct from reasonable classification. Don't get confused, it's just one of those sayings that every textbook uses, so I thought I should explain to you. You can, of course, treat one class of people differently provided you have reasons for it. So, what is most important is that you must have reasonable explanation why you are treating somebody differently. Now, I'm going to be taking up, as I told you, this Anwar Ali Sarkar and Kathi Rani Rawat cases, and this is. Just give me a moment. I want to pull up the Anwar Ali Sarkar because I want you all to. Want to share my screen actually. Okay, have many of you read this and come?
Yes, ma'am.
Good. Okay,
Yes,
now.
ma'am. Yes, ma'am.
Yeah. So, unless you read beforehand, many of the points we're going to make in class may just be. Okay, now just one moment. Let me pull up this particular most famous paragraph of Justice Das. In, yeah, here we go. Now, in Anwar Ali Sarkar, Section 5.1 of the Bengal Special Courts Act allows a special court to try classes of offenses, classes of cases, and cases by a special procedure. So, the procedure under the then Criminal Procedure Code 1898 will not apply. And under the Anwar Ali Sarkar Bengal Special Courts Act, what you will find is that there is no committal trial, as I mentioned yesterday. The judge who hears the evidence does not need to record verbatim, that is word for word, whatever is stated, but he can reduce to a substance and record only that. Revision and review is not permitted. Transfer of the case is not permitted. De novo trial is not permitted. And there are so many restrictions which deviate from the normal procedure. Now, the question before the court was, if a person is going to be tried and he goes for a normal trial under the CRPC, he will have a more elaborate and a long-winded trial, which would perhaps give him a greater chance to establish his or her innocence. Whereas if the case is transferred to a special court which operates as a sessions court, but without a jury system and without a committal proceedings, okay, that's the special court. It continues to be a sessions court. Then his or her trial will take place in this more short-circuited manner, and there is a likelihood of, justice not being carried out, okay, a miscarriage of justice because of the truncated procedure which is going to be adopted by the special courts. And this is the reason why it got challenged. The validity of Section 5.1 of the West Bengal Act was challenged, went before the High Court of West Bengal, which agreed that it was ultra vires and struck down Section 5. And then the state of West Bengal comes in appeal to the Supreme Court. 7 judges try the case, and simultaneously they are also trying the Kathi Rani Rawat case, where except for one or two changes, Saurashtra, which is the earlier Kathiawar states which have come together now to form Saurashtra, have more or less a special, through ordinances, have created another law. Now, in the Kathiawar case, that is in Saurashtra, all the princely states of Kathiawar were not part of British India. As a result, the CRPC 1898 did not extend to those princely states. When they all got together and acceded to the Union of India, And you know that Sardar Patel played a major role in getting these princely states in Gujarat and Rajasthan to accede to the Indian Union. When many of them in Kathiawar, the peninsula, acceded to the Indian Union in 1948, what the Raj Pramukh did was he issued his first ordinance extending the CRPC 1898 to these states. Then, subsequently, through an ordinance, the Special Courts Act was passed. And then, through the third ordinance, deviations also took place, more or less like the West Bengal Section 5.1, the Section 11 of the ordinance here, except that I think the only deviations in the Saurashtra case were that a revision and review under the CRPC was still permitted, and there were minor variations of that. But in essence, there is a short circuiting in the procedure that was to be adopted. And once again, a person who is convicted of murder by the special court. Remember, I already told you that the special court is in essence, a sessions court. And as students of law, you know murder can only go before a sessions court. And he was convicted, and that's how Kathi Rani Rawat, who's the person accused under 302 of IPC, comes in appeal to the Supreme Court saying that Section 11 of the Saurashtra Ordinance is bad. Now, the same 7 judges hear both the West Bengal and the Saurashtra case. And when the case was proceeding, for 2 weeks, Kathi Rani Rawat's case gets adjourned because the Attorney General says, I want to file an affidavit, the Advocate General, excuse me, and they get that on record. So 2 weeks later comes the decision in Kathi Rani Rawat case. And let's begin backwards first. In Anwar Ali Sarkar, majority of the bench in Kathi Rani Rawat case, you see a magical reversal. 4:3, the law is upheld. And instead, we are told that the law itself is intra vires the Constitution. It does not violate Article 14. However, if a notification issued under that law is seen to be unreasonable, then we will strike down that notification. As students of law, what you must now understand is that you are not exercising your powers of ultra vires under constitutional law to strike down the law as ultra vires. But in Kathi Rani Rawat's case, all you're willing to do is the law is fine, it's upheld 4:3. Yet, if tomorrow a notification is issued about you have some objection to why a particular class of offenses is sent to trial, then if it is outside the scope of the guiding principles of the law, then that notification can be struck down. Now, the exercise of using 14 to strike down a delegated legislation or a notification issued under a parent act is an exercise of administrative law. That is, in Kathi Rani Rawat, constitutionally upheld, but the possibility of using administrative law and Article 14 to strike down a notification issued under that law, that possibility still remains. You will notice that 14 is a handmaid for both constitutional law and administrative law. After Anwar Ali Sarkar, as I mentioned in yesterday's class, there have been probably just one handful of cases where the court has used 14 to strike down a law. Instead, what you find is great deference to the executive and to the legislature, particularly to the legislature, using the principle of presumption of constitutionality to refrain from striking down a law. So, for example, in 1981 is the famous Bearer Bonds case, R.K. Garg versus Union of India. One moment. Let me tell you the citation. It's actually an interesting case, and why I'm saying it's interesting is if and when the bench is set up for hearing the electoral bonds matter, it's going to have R.K. Garg, the Bearer Bonds case, to deal with. So the bearer bonds, one more. You see, like you, I also have copious notes. So I have to locate it. Yeah, Archegag versus Union of India, 1981, 4 SCC 675. Here again, just like the electoral bonds matter that is pending before the court today, the government of that day had issued bonds, bearer bonds. You could go and purchase a bearer bond by actual cash, no questions asked. And the question was whether this was violative of the constitution or not, whether it was a reasonable classification or not. And the court 4:1 had upheld it. Okay. Now, after Anwar Ali Sarkar, as I mentioned, there have been very few cases where a law has been struck down on 14. Hardly ever. Now, in Anwar Ali Sarkar, the Chief Justice Patanjali Shastri had upheld the law. He had upheld the law on the ground. He accepted a argument put forward by the Attorney General that the intention to enact this law was a noble one, because during those period of partition there were large number of crimes going on which needed quick speedy trial in order to bring justice, and the intention was not at all evil. It was not made with an evil eye or an unequal hand, as this is often put. Not made with an evil eye or an unequal hand. The intention was pure, and once the intention is pure, the law should not be struck down. Now, this argument that a law's virus, the validity of the law depends on the intention of the legislature that passes it, is an argument that was, of course, accepted by Chief Justice Patanjali Shastri, but was rejected by everybody else. And today, 70 years down the line, the court does not use the object of the law to determine whether a law is valid or not, but it looks at the effect of a law. Now, this distinction between intention and object and effect is something we already studied last semester. Can somebody tell me where we studied this? Doctrine of
Colorable legislation.
Okay. Any other?
State of West Bengal versus Union of India, there was written that object of the act cannot be used to determine the validity of it.
Did we also not study substance? Yes.
Yes,
It's a
ma'am.
substance also, where the broad principle now is to test the validity of the law. We don't look at the intention, but we look at its effect. And this has got deepened over a period of time. When I come to R.C. Cooper and I come to Menaka Gandhi in Article 21, it will be reiterated. So, in the first case that ever came before Article 14, this was the argument put forward by the Attorney General, accepted by only the Chief Justice, but by no other. And so, therefore, this, as a general question, as students of constitutional law, how much, in criminal law, we are looking at intention, we're looking at object of the person. But we never look at intention and object of the legislature. We only look at the effect. What is the effect, and we evaluate its validity based on the effect. The other argument that Chief Justice Patanjali Shastri found favor with him was that even if you classify the number of cases that go to special courts and special procedure is a very minimal number, and therefore the Attorney General argued, since there's just a handful of cases that are going to special procedure, we must not strike that special procedure down. Now, if you were to think about it a little bit, this is really what in the United States constitutional law we call as a de minimis rule. That if there's only minor variation or minor deviation, then the law as a whole is upheld. And the same de minimis principle was actually used, unfortunately, by the Supreme Court in the Kaushal case, which reversed the Nas Foundation. Now, all of you know, at least I assume that you must know. If you don't know, I'd be truly surprised. That the Nas Foundation case of the Delhi High Court had struck down Section 377 of the IPC and homosexuality. When it first went to the Supreme Court in Kaushal versus State, a two-judge bench of the Supreme Court had reversed the Delhi High Court opinion, and one of the arguments put forward was a de minimis rule. It said there's a number of homosexuals in India is so minuscule, so even if 377 is going to deprive them of their rights, even if they are consenting to have homosexual relations in the privacy of their homes, the number is so small, so this cannot be a ground to strike down the law. That's a clean application of the de minimis rule. Of course, subsequently, as we know, as you all also should know, that after the Puttaswamy 9-judge bench decision, once again, the privacy rights versus was used to test 377, and in Navdeep Singh Johar, the Nas Foundation judgment was upheld and Kaushal was overruled. And in fact, in that judgment, the court does say whether it is one person's right which is getting violated through a bad law. The fact that it's only one person who's affected through a bad law cannot be a ground for saying चलो चलो कोई बात नहीं ऐसे नजरअंदाज कर दो, just ignore it. ऐसा नहीं हो सकता. If a law is good or bad, it does not matter whether one person is affected or 20 persons are affected. So persons affected by a law is different from the effect of a law. The effect of the law is to affect only one person. But even one person is one person too many because he or she has the right to fundamental rights. Unfortunately, Chief Justice Patanjali Shastri accepted this view of the Attorney General and he said, yeah, it's a small number, koi baat nahi chalega. That kind of view was the minority view. The majority view of Justices Fazl Ali, Justice Mahajan, Justice Bose, Justice B.K. Mukherjee, and Justice Das partly took the opposite view. And Justice Das, who wrote, I told you all 7 wrote. It was a given thing in the early 50s that all 7 would write. So you have 7 judgments in A.K. Gopalan. You have 7 judgments in Kanti Rani Rawat. You have 7 judgments everywhere. So everybody wrote. Okay. Now, Justice Das, and I'm going to share my screen now because I want you to see, because this paragraph is, according to me, like the classic paragraph of Article 14. This is just one paragraph I'm going to read. Let me share it with both the classrooms. Good. Can you see it, please? Can you see my screen?
Yes.
Okay, thank you. Okay, now just these 2 paragraphs is what I'm going to read out. Okay, and I'm somewhere here, if you can see my cursor. The meaning, scope, and effect of Article 14 of our Constitution has been discussed and laid down by this court in the case of Chiranjeev Lal versus Union of India. Chiranjeev Lal versus Union of India. I'm just reading this, I'm speaking now. Chiranjeev Lal versus Union of India is like the classic case for the proposition: can there be a single member classification of a law? That is, can I have a law which is only pertaining to one person? Would it be valid? Or do I need groups, a whole group, in order to have a classification? And Chiranjeev Lal, where under the laws it then stood, the old Companies Act, a company was taken over, and the takeover of the company was done by a legislation pertaining to one company. The court felt that even when you're classifying, if there is one single person who must have a special legislation that does not violate Article 14. So, for example, the fact that University of Delhi is governed by the University of Delhi Act 1922 and it is a law pertaining only to one person, namely Delhi University. Does that violate the classification principle? Why aren't all central universities treated under one law? Our answer will be that under Chiranjit Lal, if you can show that there is something so peculiar about this university that you can have a single person law, that does not violate Article 14. So merely because BHU, DU, Allahabad, all these central universities are not clubbed together under one law is fine. So even now, when we have a Central Universities Act 2009, that governs all the newer central universities that were set up in 2009, one to each state. But the grand old central universities, namely Delhi University and BHU, which are really the oldest and the grandest, continue nevertheless, okay, with their own single person law. I come back now again to this paragraph, please. The meaning, scope, and effect of Article 14 of our Constitution has been discussed and laid down by this court in the case of Chiranjit Lal versus Union of India. Although Justice Patanjali Shastri, as he then was, you must have come across because he subsequently, after the very premature death of Chief Justice Kanya, Justice Patanjali Shastri became the Chief Justice. You know, it was totally unexpected when Justice, there's this very nice book, George Gadbois' book, that looks at the lives of all our different judges, and there's a very good account of all that happened in the early days of the Supreme Court. He's written two books. One is called The Federal Court, the other is called, I can't remember what the name of this other book is, George Gadbois, Gadbois. Please get hold of it and read it because it gives you all this background sort of, stories, juicy stories really, about all that is happening in the Supreme Court. And you can see what a lot of calculations went into elevation from the bar to the bench, etc. Okay, though Justice Shastri as he then was, and myself, and this myself is Justice Das, S.R. Das, differed from the actual decision of the majority of the court, there was no disagreement between us and the majority as to the principles underlying the provisions of Article 14. The difference of opinion in that case was not so much on the principles to be applied as to the effect of the application of these principles. Those principles were again considered and summarized by the court in State of Bombay versus F.N. Balsara. Remember where I discussed this when I was talking about doctrine of severability. It is now well established that while Article 14 is designed to prevent a person or a class of persons from being singled out from others similarly situated, I'm emphasizing this word, is designed to prevent a person or a class of persons from being singled out from others similarly situated for the purpose of being specially subjected to discriminating and hostile legislation. It does not insist on an abstract symmetry in the sense that every piece of legislation must have universal application. All persons are not by nature, attainment, or circumstances equal by nature, by their attainment, that is what they've attained in their life or their circumstances, they are not equal. And the varying needs of different classes of persons often require separate treatment. Okay? Not equal, but separate but equal. And therefore, the protecting clause has been construed as a guarantee against discrimination among equals only, and not as taking away from the state the power to classify for the purposes of legislation. Just read the sentence again. All persons are not. It's a very profound sentence which captures the essence of 14. That people who are equally situated, there can be no discrimination. You cannot pick and choose and do cherry picking among them. But amongst people who are differently situated, you can treat them differently. This classification may be, I'm going back to reading, this classification may be on different bases. Bases being the plural of bases, different bases. It may be geographical or according to the object or occupations or the like. Mere classification, however, is not enough to get over the inhibition of the article. And here comes the true test. The classification must not be arbitrary but must be rational. So if I'm going to have two buckets into which I'm putting people, men in this bucket, women in this bucket, it must not be arbitrary, it must be rational. That is to say, it must not be, excuse me, it must not be only be based on some qualities or characteristics which are to be found in all the persons grouped together and not in others who are left out. But those qualities or characteristics must have a reasonable relation to the objects of legislation. That is, the classification must not be arbitrary, it must be rational. That is to say, it must not only be based on some qualities or characteristics which are to be found in all the persons grouped together and not in others who are left out, but those qualities or characteristics must have a reasonable relation to the objects of legislation. In order to pass the test, two conditions must be fulfilled, namely one, that the classification must be founded on an intelligible differentia which distinguishes those that are grouped together from others, and number two, that the differentia must have a rational relation to the object sought to be achieved by the act. The differentia, which is the basis of classification, and the object of the act are distinct things, and what is necessary that there must be a nexus between them. Just take a moment to read this two lines again because I'm wanting now to discuss it in the light of Anwaradi and Kaviraj. Okay, so now to just sort of make it a little simpler, let me give you two, three scenarios so that we are clear that we've understood what this test is laying down. Suppose I have a law which says all people with black hair will be in category A, all persons with non black hair will be in category B. And I then say that persons who do not have black hair will be, because they are old, will be given a 50% tax rebate. That is, what is the object of the law? The object of the law is to give a tax rebate to older people. But how have I classified in order to identify those old people? I've said people with black hair and people with non-black hair. Now, this classification itself may be a reasonable way to classify people as black hair and non-black hair people. But you will immediately see that there is no rational nexus between this classification and the object of the law. Because the object of the law is to give older people a tax rebate. You may be a person who has, for whatever reason, prematurely gray hair. There are many young people who start going gray in their teens and in their 20s. Many of them, but who are not old. There may be people who, for whatever reason, have alopecia and have lost all their hair. They cannot fall into the bucket called with black hair. They have to fall in the bucket without black hair. Now, while the classification seems rational, those with black hair, those without black hair, the first limb of the test is satisfied. But the second limb of the test that has a reasonable rational nexus or a connection or a logical connection to the object of the law is not being fulfilled, because this method of classification, it would have been far better if I had said all those below 60 in one bucket, all those over 60 in my second bucket. And then I say all those who are in my second bucket will get my 50% tax. Because there I'm actually having a reasonable connection between age and the object of the act. Because the object of the act is to give older people some tax benefit. Okay. So there is a rational basis of classification, plus it has a rational nexus to the object of the act. So Justice Das very famously laid down the the nexus test, as it is called. That is, there must be on the first limb a rational basis of classification, and this rational basis must have an intelligible differentia. What does that mean? If somebody asks वो उस category में क्यों गया और ये दूसरे category में क्यों गया, there must be a reasonable, intelligible way of explaining that. It cannot be मनमर्जी, मैंने सोचा, मैंने बोला, इसीलिए वो वहां गया. That is not an intelligible difference here. वो तो that is just subjective. That is acting like a Mughaliya Badshah. That is completely arbitrary. You must explain, I've put all people with black hair here and I've put all people without black hair here. It must be clearly understood how to classify. And it must have an object. Now Justice Das goes on to further to say that the basis of classification cannot be the same thing as the object. If your object is older people have to be given a tax rebate, and you say my basis of classification is category में old people हैं और इस category में non-old people हैं, it is the same basis as the object of the act, but it is illogical because it is circular. अगर आप ये पूछेंगे, if you ask, but how do I decide who is old? Then my answer will be क्योंकि मैंने उस category में डाल दिया, इसीलिए वो old है. I've put them in that category, that is why it is old. It is in logic what we call a tautology, that there is no reason to explain who is considered old. I neither say he must have black hair, neither do I say that that person must be over 60 years old. I just say he's old, that's why I put them there. So, sometimes I tell you in class, you ask student, why have you come late? They say, late ho gaya. That's a tautology, because you are not giving me any additional reason why you got late. You're just telling me I got late. So Justice Das says that the basis of classification cannot be the same thing as the object of the law. Look at this sentence. The differentia, which is the basis of classification, and the object of the act are distinct things. Okay, and therefore they cannot be the same. The reason he's saying this is, in the West Bengal case, the Attorney General came and argued that I will put those offences, classes of offences, cases and classes of cases to the special court which requires speedier trial. And then the court said, so how will you decide which has speedier trial? And he answered back, all those cases that I'm sending to the special court are the ones that have speedier trial. That is, the object of the act and the basis of classification were the same. And the court says that that is not possible. There must be reasonable guidance in the law to explain which is how you are going to decide which case will go to special trial and which case will not go. You must have guidance in the act. And if you look at the section 5 of the provision of the West Bengal Act and you look at the act as a whole, it did not explain anywhere how the government will exercise the discretion granted to it to determine which offense classes, cases will go to special court. Because the court said everything wants a speedy trial. So tell us how you will decide what will be the basis. There was no guidance given in the act. at all. And therefore, except for Justice Patanjali Shastri, most of the other judges on most points held it to be unconstitutional, and it was struck down 6:1. Okay. And Justice Das struck down the first three. His case's judgment is most interesting because he separates offenses, classes of offenses, and classes of cases on the one hand, and individual cases alone he puts on the other hand. He found only pulling out individual cases as discriminatory, but all the others he was willing to uphold. So when it came to category 4, it is struck down 5:2. But when it comes down to the other three, it was struck down 6:1. Now, no guidance was available. However, when I come to Kathirani Rawat's case, as I told you, it was adjourned for 2 weeks till the state of Saurashtra filed an affidavit. And in this case, the court 4:3 upheld it. So, in addition to Justice Das and Justice Patanjali Shastri of Anwar Ali Sarkar, Justice Fazl Ali and Justice Mukherjee also shifted their positions. So, 4:3, they upheld the constitutionality of the Saurashtra Act. Now, when you come to Justice Fazl Ali and Justice Mukherjee's judgment, which is there, I'm just about to ask you a question. You will notice that Justice Mukherjee says that in the Anwar Ali Sarkar case, we laid down the test of discrimination with reason and discrimination without reason. That is, if I am going to pick up some cases and send it to special trial under the special courts, there must be reasons for it. If there are no reasons for it, it is arbitrary and it is violative of Article 14, because people who are similarly situated are unfortunately going to face different type of trials, and you have no reason or no explanation to give why वो आदमी स्पेशल कोर्ट में जाएगा जहां पे जल्दी जल्दी से the decision will be given, and the other person will have all the procedural safeguards available under the CRPC 1898. Okay, so he talks about discrimination with reason and without reason. Yet they are able to find discrimination with reason in the Saurashtra ordinance in order to uphold it. So those of you who have read the case, what to your mind are the key reasons for the same 7-bench decision now upholding Saurashtra, whereas they struck down West Bengal? Anybody, please, who's read the case?
May I?
Yes, who is that speaking?
Ma'am, Ankita.
Okay, Ankita, please go ahead. Yes.
Ma'am, in the Saurashtra case, ma'am, the circumstances, first of all, were such which demanded the speedier trial of the cases, ma'am, because of the increasing number of the criminal cases which were pending, and they were getting appended to the near end, ma'am. And there was no end to disposing of these cases, ma'am, and therefore these special courts did require to be set up so that they could be disposed of easily. And ma'am, second thing that the powers which they gave, ma'am, the court to dispose of certain cases, ma'am, and there was the Attorney General has given the rational nexus between setting up of these cases to be given to the judge.
Okay. Does anybody else want to supplement what
May I, ma'am?
Yes, Swarit, yes.
Ma'am, the court basically looked at the aims and objectives behind third as well as the second ordinance, and said that both were the special courts provision, section 11 of the ordinance. Basically, it was necessary because there was a deteriorating law and order situation, and the aim and objective of in the preamble clearly state that the setting up of special courts was dedicated towards rectifying this situation. Further, the court also noted that the limit of the ordinance was also geographically restricted. Therefore, both in terms of offences as well as in terms of the area, there was a rational basis for classification.
Right. So, you've supplemented what Ankita said. Now, both of you, what you are saying is guidance which was missing in the Bengal case, because there was no guidance given in the text of the Bengal Act about what kind of classes of offenses or cases will go to special court, and there was no guidance given to the executive, but the executive had been given the power to shift some cases and offenses to the special courts. No guidance given. Whereas in Kathi Rani Rawat, they found guidance in two areas. One, the preamble noted that in those particular districts or taluks, which are these, I heard them for the first time, so I was very interested in which is those three places in Saurashtra. I never heard of them before. Does anybody remember? See, I keep telling you, and I myself have not marked it. Huh? Which paragraph? It mentions three districts in Saurashtra, which I never heard of before. Anyway, one, the area was demarcated. It said in order to deal with growing violence, and geographically those three areas were demarcated. Number two, the kinds of offenses also was shown. Nose cutting, dacoity, killing. Yes, Gilward. Yes, that's right. Which paragraph is it? Whoever just now answered. नहीं पेज वेज मत बोलो, पैराग्राफ बोलो. Para. Okay, anyway. The kinds of offenses that was taking place in this place were also. So this seemed to attract both Justice Mukherjee and Justice Fazlali, because they say, if you look at paragraph number 11, please look at paragraph number 10 and 11. Sorry, paragraph 20. Paragraph 20. I'm at paragraph 20. As regards the present ordinance, we can discover a guiding principle. What is the guiding principle? Some 7-8 lines further down, the ordinance, as I have already stated, purported to amend another ordinance, the object of which was to provide for public safety, maintenance of public order, preservation of peace and tranquility. Okay? And in the preamble, some further lines down, the clear recital of a definitive objective furnishes a tangible and rational basis for classification. The basis of classification which they felt was missing in West Bengal, they found supplied by the preamble. And what did the preamble say? Further lines further down, the state government is expected to select only such offences or classes of cases for being tried by the special court in accordance with the special procedure as are calculated to affect public safety, maintenance of public order under section 9. It must be confined only to those disturbed areas, which I mentioned, or those areas where adoption of public safety measures is necessary. So the geographical limitation imposed by the preamble allows you to classify those cases in those areas. Number two, if you come to the second part of that same paragraph, the notification also specifies certain areas in the state over which the special courts will exercise jurisdiction. So therefore, both the types of cases and offenses which are likely to affect public safety and the geographical area is laid out in the preamble. In addition, as I told you, an affidavit was also filed by the state when they adjourned it for 2 weeks. And when they adjourned it, they also made it clear that we will rely on these provisions in the preamble to limit the exercise of jurisdiction to those cases which are going to deal or affect public safety. And in those three areas, which somebody's telling me page 86, but those three geographical areas are listed somewhere in, here we go. These areas, yes, paragraph 35. The second part of paragraph 35. It's a longish paragraph. 9th, 11th Feb 1950, which constituted a special court And here the affidavit shows, look at the affidavit, shows that all these areas are included in the districts of Gohilwad, Madhya Saurashtra and Surat. I think Surat means Surat, huh? Okay. So
No,
then
that is different.
That's different? Okay, okay. I stand corrected. I stand corrected. So we're the tribe of marauders, principally. So what you will notice is that because the preamble designated those offenses which affect public safety and maintenance, those extra words were there, missing in West Bengal. Number two, the areas also were demarcated by the affidavit. These two, the court felt, gave sufficient guidance as the basis of classification. So in Bengal, they had said the object of the law, speedy trial, the basis of classification also cannot be only those cases that require speedy trial. How do we know how you're going to pick and choose? There's no guidance there at all. But here, the guidance is provided by the preamble and the affidavit, which says we will only restrict it to those cases affecting public safety and in these geographical areas. So the limitation is there, the basis of classification is there, and voila, what you find is that you have 4:3, the judges upholding the validity of section 11 of the ordinance. And what therefore you also find is that Justice Mukherjee, this poor Kathiraning Rawat, he committed murder. Look at the tragedy of this man's case. His case was sent to special trial. What is a class of offenses? Offenses against the body. This man had been charged with 302. So I just want you to look at this last paragraph of Justice Mukherjee's judgment. I thought it was extremely interesting. So if you have the case open in front of you, come right to the last paragraph, last but one paragraph, the second part of para 37. He says a too rigid instance therefore on an insistence therefore on a thing like scientific classification is neither practicable nor desirable. He says that we can't be very scientific when we are classifying. Then come to para 38. Be that as it may, I do not think a meticulous examination of the various offences specified in their list is necessary. Because what happened is, when you look at dacoity by in the dwelling house is inside the list, but dacoity outside is outside the list. So the category of dacoity entirely does not go to special court. Some are here, some are there. So that was challenged, and he says, no, I don't think we should be splitting our hairs. We shouldn't be doing such a detailed examination. Here, every offense against the body was not sent to special trial. For example, section 308 went to normal trial, but murder went to special trial. So Khatir Haning Rawat said all offences against the body haven't gone for special trial. Mera case to chala gaya, but 308 is still lying outside. But the court then says is, look at the middle of paragraph 38. I found this paragraph terribly interesting. As he is accused of murder and dacoity, the third line, there is no other offense, I believe, described in the Indian Penal Code which can be placed on an identical footing with murder. Even culpable homicide not amounting to murder is something less heinous than murder. Although it finds a place in the list, it goes also to special trial. In my opinion, the appellant can have no right to complain if he has not been aggrieved in any way by any unjust or arbitrary classification. As he is accused of murder and dacoity and no offences of a similar nature are excluded from the list, I do not think it is open for him to complain of any violation of equal protection clause in the notification. Meaning thereby, had a person of a lesser crime said that there is no complete classification, maybe the court may have heard it. But this man came with murder on his hands, convicted of murder by a special court. And because of that, the court says that right at the end, last two lines of the case, the question of inequality on the grounds of such omission can be raised only by the person who is directed to be tried under the special procedure for a certain offense. Whereas for commission of a similar offense not mentioned in the list, another person still has an advantage of ordinary procedure. So discrimination can only be if one person who is charged with offense of, let's say, grievous hurt is tried under special court, but another person is tried elsewhere. But in this case, the court says murder stands on a category all of its own. So even that is not available. So to sum up, look at Kathirani Rawat. You will see when I began by saying that there's great deal of judicial deference to uphold the law, that there is a presumption of constitutionality, and the court who is willing to see if they can uphold it because there is a presumption. In Kathirani Rawat, they were willing to look at the preamble because this is preamble is the key to open the mind of the lawmaker. So the preamble also being read as part of the law, and an affidavit filed by the executive to say we will confine the reference of cases to the special courts to these three geographical areas and to only those offences that affect public safety, and that is accepted by the court as a reasonable guidance to provide the basis of classification. So, on that basis of classification, you classify cases as going to CRPC or to special procedure, and this special procedure is having a rational nexus with the object of the act, which is to provide for speedier trial in certain offences and in certain cases. And therefore, after this Kathirani Rawat case, special procedures, it's very difficult to strike down special procedures because you will always find something in the preamble of the act which will give guidance to the executive to decide whether the case should go for special trial or to normal trial. Now let me come back last few minutes if I have time, but I don't. So I will now stop here and I will take attendance. Is there any question anybody has for a minute? If you can ask me.
Ma'am, I think you can continue because we don't have class after this.
No, but I have class. I have a section D class. So I can't continue. Okay.
Ma'am, I have a question. I was wondering that in a lot of judgments, courts say that the misuse of a law is
Yes.
not ground to strike it down.
Yes.
I'm wondering if that is also something quite similar to de minimis rule, because the misuse will be a lot
Not
lesser.
similar to de minimis rule. I don't know who's asking that question. It's not similar. The reason it is not similar is de minimis rule is only for minor variation. But the power under the law is granted to you. Suppose I have the power and I say that I can grant licenses to somebody who is above 18 and knows how to drive a car. In a particular case, I decide not to give this man a license because I have a fight with his father. Okay. Now, this exercise of the delegation, which is nothing other than a notification, right? Where I say that these people will go. That exercise of discretion granted to me can be struck down on grounds of being mala fide, but that does not make the original provision which granted the power to delegate to the executive, that will not be bad. So in constitutional law, the delegation of power is upheld. Yet the exercise of delegation is struck down on grounds of administrative law, either for non-application of mind or for mala fide purposes. And that cannot be equated with the de minimis rule. No, it can't be. That's a distinct point. Okay, now my attendance, for some reason,